Hi, good evening, everyone. Sorry for taking your Sunday when you are supposed to be resting or doing some other things of your own choice. So we are going to discuss one outstanding thematic area from law of corporate finance. So tonight we are going to discuss issues about shareholder rights, identification of shareholder rights, and their enforcement. So we hope to make it as fast as possible so that we're able to get out of here. So we will do three basic things just to remind ourselves first and foremost about how the status of the shareholder is acquired. Then we will explore the spectrum of rights which are available to shareholders. And we will look at the remedies or the various mechanisms for protecting the rights of shareholders as it were. Now, in order not to get a feedback from some of you who sometimes forget and leave your mic on, I have endeavored to mute almost everyone. So if I ask a question or I raise an issue and I want to get you to participate, I will prefer that you raise up your hand and then you are invited to unmute yourself. And as soon as you finish, and then you mute yourself back. So that way we are able to have a very nice engagement. So thank you very much. Just a minute, let me lock my study room so that I don't get disturbed. Okay, so first and foremost, we need to be clear who a member and shareholder is. Of course, the word member and shareholder may be used interchangeably. That is to say that if you say a member, it could mean a shareholder. And if you say a shareholder, that could also mean a member. But it's not all the time that such interchangeability will be true. What do I mean by that? That is to say that there are times, it may be perfectly correct, to just use the word member of a company on one hand and then shareholder of the company on the other hand, without even thinking about any differentiation between the two. You may be right in some cases, but on another occasion, we may not be correct in saying that. And it all depends on, one, the type of company. If we are talking about a company limited by guarantee, for example, if you use the word shareholder, certainly it will be wrong. It doesn't mean a member. So that is what we mean. But of course, if you are talking about company limited by share, then in principle, and also theoretically speaking, you're absolutely correct to be interchanging the word member for shareholder or shareholder for member, because by definition, in our law, at least going by Ghana's companies legislation, 992, every member of a company limited by share is required to have at least one share. And for that matter, it is absolutely correct to be interchanging these two words. On the other hand, if you are also talking about company limited by shares, it's not all the time that it may be correct for you to say that a member is the same as a shareholder, or a shareholder is the same as a member. Why do you say that? Because you could have been, given shares, you could have been issued shares, allotted with shares, but that is not enough for you to be a member, because if you look at the law, especially if you look at the section now, I hope you remember your basics. If you look at section 33, subsection 2, for example, right? There's a provision to the effect that any other person who agrees with the company to become a member of the company and whose name is entered in the register of members is a member of the company. So whose name is what? Entered in the register of members. So that is to say that you might have agreed to become a member of the company limited by shares. You'll be given shares, but the other related process of entering your name in the register of members has not yet been done. And for that matter, an argument could validly be sustained to the effect that you are not a member, despite the fact that you are a shareholder by reason of you having been, if you like, giving share as it were. Of course, I must say that some of these things are very extreme theoretical possibilities. But the fact that there are possibilities also means that we cannot just sweep it under the carpet. That is to say that it can happen despite its remoteness. And of course, you all remember the case of Asibi and at the Shemine Gardens, in which these issues as to when can we say that a person is a member of the company, or when can we say that a person is not a member of the company, and all that came up. And that one, I mean, part of the confusion really has to do with those who were original subscribers to the regulations of the company. Regulation was the old language which used to be used for what we now call the constitution. And at the time of incorporation, some people were subscribers. They signed the incorporating document. And for that matter, they were given shares. They had not fully paid for the shares. And at some point, some of the members and directors decided to treat those subscribers who had not fully paid for their shares, for example, as having ceased to be a member and all that. And eventually, when it became a subject matter of litigation in the courts, right out from the High Court to the Supreme Court, the point was made by the court that we have, if you like, two main types of membership of the company. If you like, membership by subscription, and I mean subscription to the funding or the incorporating document on one hand, and then those who subsequently agree to become a member, that is after the company is really incorporated. Yeah, and then it was there that the court would make the point that if the person's name is entered in the register of members and all that, then that person is a member. And it's not necessarily when the person has paid for the shares or has not paid for the shares, especially so where there has not been any call on a person who was previously given shares and has not fully paid for the shares, as it were. Yeah, so, but these are an important minor preliminary things we should have at the back of our mind. Good. So this brings us to our core business for tonight's session. The rights of shareholders, or fundamental rights of shareholders. What are the basic rights of shareholders? And of course, people don't acquire shares just for the sheer fun of just having shares. Human beings, we are reasonable creatures. We are rational creatures. And for that matter, every action of ours has got a certain motivation, has got a certain reason why we acted that way. For that matter, if someone decides to invest in a company, for which reason he becomes a shareholder, that should confer him with certain entitlements, with certain legal claims, which he can make against the company or against those who are in charge of the company. And those legal claims, those entitlements, which he can make from the company, are what we call the rights of the shareholder. And of course, there are a whole gamut of rights, but we don't have the luxury of time. So we will focus on what we call the fundamental or the basic rights of shareholders. I noticed, Frank, your hand is up. Just hold your fire for a second. I'll come to you. Now, so shareholders' rights, I would say, if you like, emanate from three sources. Let me put it that way. It come from three origins: statutory, quasi-statutory, and contractual. Yes, let me take Frank and then we move on. Yes, Frank?
My lord, about the member and shareholder discussion you just had, as you said, there are some theoretical possibilities, but just looking at the same section, subsection 4, which more or less says that a member is a shareholder. And so I'm just assuming that you cannot be said to be a member unless you are a shareholder. And so my understanding is that members are also shareholders, but you're saying that it's not always that is the case. I'm just thinking that one cannot be a member if the person is not a shareholder, at least by virtue of subsection 4. I don't know if...
Subsection 4, mean 33.4?
Yes, that is so.
Right. All right. Yeah, so thank you, Frank. So as I indicated, it is a question of context, like the particular perspective from which you are looking at. As I said, it is, I would say most times when you say shareholder, it's a member, or when you say a member, it's a shareholder. But I qualified it by saying it depends upon the type of company. If you are not dealing with the company limited by shares, then if you say a member, it doesn't mean a shareholder. For example, if you have a company limited by guarantee, we know companies limited by guarantee, they are not supposed to create shares. So therefore, if you say a member in relation to that, it doesn't mean a shareholder. So that was one particular explanation for that. Then the other point we were trying to make is that, like the four that you quoted, in the case of company with shares, each member is a shareholder of the company and shall hold at least one share. Good. So a company limited by share, yes, every member must have a share. But within the short period where you are, for example, you'll be giving shares and then the process, the issuing process, the allotment process, for example, has not completed in the sense of you having even your name entered in the register of the members. So by reason that you'll be giving shares, we've made some valuable consideration and all that, you're a shareholder. But because your name is not entered in the register of members, if we go and inspect the register of members, your name will not be there. And for that matter, an argument will be made that you are not a member. But as I said, that will just be a question of time, just a momentary thing, maybe because there has been administrative lapse on the part of those who are in charge of doing the entries. That is why such a possibility may, for example, arise as it were. Or let's say that we're giving shares under the terms of payment. You are supposed to have paid by a certain time. You haven't finished paying it, then the right of forfeiture is exercised by the company. And when the right of forfeiture is exercised, then you also lose your membership. But that one is a different matter. But as I said, this is just a extreme possibility, but because it's a possibility, we cannot ignore it without being aware of it. John Warasi. Yeah, John, your hand is up.
I think your explanation has covered my question.
Okay.
So it's okay.
Okay. All right. So I was making the point just before the question that shareholder rights emanate, if you like, from three main sources. The first, you could say, statutory. That is, they are created by a statute legislation. So typically, we have like the Companies Act, for example, Act 992, and from section 1 up to the end, in various ways, you get various rights for shareholders, as it were. And we also said quasi-statutory. Quasi-statutory here, I'm referring to where the company, for example, has adopted a registered constitution, right? Now, in that constitution, the company may create certain rights, certain entitlements, certain claims for the shareholders. And for that matter, we say that the rights or those claims which the shareholders will be enjoying in that respect emanated from the constitution. And this constitution is sanctioned by the act, and that is why we are calling it the quasi-statutory. So the constitution itself is not, if you like, part of the provisions of Act 992 for that matter, any other legislation, but it is a legislation which lays the foundation for adoption of such a constitutional document. And then the third possibility is a contractual. Contractual in the sense that you will notice very soon when it comes to like the shares, right? When it comes to shares, for example, shares is an agreement between the shareholder and the company. So within that, various rights maybe work out when they are being created. But I have quoted or cited section 33, subsection 3. So let me quote that in a minute. Section 33, subsection 3. I have my legislation in front of me. So quote. A member has the rights, duties, and liabilities that are by this act and where applicable by the registered constitution of the company conferred and imposed on the members. Yeah, so section 33.3 is just reinforcing the point that we have made. And again, just to also let to appreciate that it is possible for more rights to even be created for the shareholder through the terms of issue of share. Let's look at section 42, subsection 2. Quote, the number of shares in the company and the right and liabilities attaching to the shares are dependent on the terms of issue, unquote. I'm very much interested in the second component of the provision in section 42, subsection 2, the second component, which says that, quote, and the rights and liabilities attaching to the shares are dependent on the terms of the issue. So rights and liability attaching to the shares are dependent on the terms of the issue. So that is a contractual bit I was endeavoring to allude to earlier on. Let me see what is in the chat. Okay. Kweku, can you hear me? Or still not clear from your end? You can just put it in the chat if you can hear now. Okay, I think it's not here. All right. Okay, so let's take some of these rights of the shareholders. One, the right to attend general meetings. The right to attend general meetings, as we say in section 34, is quite fundamental. Now, you notice if you go to section 144, for example, in terms of powers within the company, it is structured, if you like, in the dual system, or is dualized. We have the members in general meeting on the one hand, and then we have board of directors on the other hand. Now, powers which are given to the shareholders collectively in general meeting can only be enjoyed where they actually meet. And that is why we say that the members in general meeting, when they meet, if that is the case, then if you're a shareholder, you must be clothed with the legal right to attend general meetings. General meetings here, be it annual general meeting, be it extraordinary general meeting, which is either even conveyed by the board of directors on their own, or they are requisitioned by some of the shareholders, as it were. You have the right to attend. And that is very important. So the right to attend also means that you have the right to be given all the notices of documents which will be discussed during such meeting. Prepared financial statements, director statements, auditor's report on prepared financial statements, and all things which are going to be discussed, your right to attend the general meeting extend to receive those things. And of course, not just the right to attend. The right to attend also means the right to speak. You have the right to speak at the meeting. You have the right to vote where decision will have to be taken. You have the right to participate in it. And of course, if you even have the right to call, to demand a poll, if you want a matter to be put to actual voting, so that the number of shares you have in the company may actually determine how much say you have in the decision making, you can demand that. Of course, there are some people, they go for meetings and then company meetings, and some are very eloquent and quite vocal. Meanwhile, when it comes to the actual number of shares that they have a very mega, just a few, a handful of shares, and yet they can do all the talking. Somebody may have significant number of shares, but let's say that he doesn't have maybe a lot of advocacy or a lot of skills in terms of articulation. So if such a person, for example, would like to have the matter put to vote, despite the fact that he is not able to articulate his ideas and carry the whole room to follow him, because he put so much money in the company, represented by the number of shares, he'll be able to have a lot of say when you put it to vote. So let my money speak for me, as it were. Let my shares count. Let my vote count. But this right to attend meetings, yes, it's fundamental, but then in some respect, it may not be sacrosanct, because it is possible in some cases, right? It's possible in some cases for the company to impose some restriction on the right to attend and vote at meeting. And for example, if you look at section 34, subsection 2, there's a provision to the effect that, and I quote, a registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the cost or any other sums of money presently payable by that member in respect of shares in the company have been paid. So the company may impose some restriction on enjoyment of this right to attend and vote at general meetings. Again, in the case of preference shareholders, I hope you remember preference shareholders as opposed to equity shareholders. Let me find out if we remember. Who can tell us the distinction between preference shareholders and equity ordinary shareholders? Anybody, any volunteer? Can just put up your hand. Yes, yeah, Alfred Alamus. Alfred, you can mute yourself.
Okay. Please, can you hear me?
Yes.
I think the preferential shareholders are those shareholders that have signed to the company's constitution to be given a certain amount of money when the company is being liquidated.
Okay.
But the common shareholders, as to the equity shareholders, for them, they have not done that. So in terms of liquidation, the preferential shareholders are paid. If anything is left, the common shareholders are given.
Okay, that is fine. So Talamus, what you have said is one of the ways in which a person will be a preference shareholder. There are other ways. So if you tell us other ways, otherwise, let's see if some other people will contribute to the other ways. What you said is correct, but that is not the only way in which someone is a preference shareholder. I think Kobina, yeah, and then John. Okay, Kobina.
Yes, sir.
Yes, go ahead.
Yes, a preference shares are mechanisms for raising additional equity, and those people are given the privilege of being able to acquire additional shares in the company, which ordinary shareholders do not get that privilege.
Not exactly. You've alluded to what we call the right of preemption, the doctrine of preemption. The doctrine of preemption actually applies to equity shareholders, or if you like, ordinary shareholders, not necessarily preference shareholders. Yes, okay, let's take John and see if he will add to the other aspect of preference share, which Alamus earlier explained. Yes, John?
Yes, preference shareholders, they take part in the profits before the other shareholders. And in some situations, if the company is not even able to pay dividends this year, for some reasons, they can accumulate it and pay it at the time that they have profits to pay the dividend. That is something like cumulative preference shareholders. So they have preference in taking that. All the ordinary shareholders, you take the residual.
All right, good. Yeah, so this, and then in addition to what Alfred told us, yeah, okay. So either in respect of dividends or return of assets, return of assets, and then the during liquidation. Okay, good. Okay, so let's move on. Yeah, so for preference shareholders, as you remember, under certain situation permitted by Section 52, their right to attend and vote at meetings may be suspended. But of course, related to the right to attend and vote at meetings is also the related democratic right to have your proposed resolution or circulars or statements circulated by the company. In other words, it's not only the board of directors who set the agenda in terms of what is to be discussed, what is to be decided at general meetings. You as a shareholder, if you look at section 168 of Act 990, for example, it recognizes your right to invite the shareholders to take a decision on anything. So you can propose a resolution, and not only propose a resolution, you are also entitled to set your thoughts down in writing, to have your statement explaining your resolution and have it circulated to members who are entitled to attend meetings before the scheduled meeting day. So all these are parts of your right. But of course, as we are told, that where your right ends, another person's right begins. So the law of defamation I'm sure the last few days, your ears are tired of the defamation in the media space. So much as the law confers a right on you to propose a resolution, to put together a statement and have the company to circulate it to members who are entitled to attend meeting, you must be mindful of the fact that you are also circumscribed by the law on defamation. That is to say that if what you are causing to be circulated, for example, defames anyone, it causes injury to reputation of any person in the minds of right-thinking members of society, then you have to bear the ensuing liability, and it will not necessarily go to the company. So that will be your own liability. So let's keep that in mind. Another right which a shareholder has got is a right to receive dividends. The right to receive dividends when declared. Okay, let me see. I've seen some two hands up. Let's take them. Okay. Let's see. Mr. Safo Kantanka. Yeah, Safo Kantanka, you can unmute yourself. Okay, it's not ready. Let's take another one. Moto G Power. You can mute yourself.
Yes, Your Lordship. I wanted to find out, in terms of the members' right to circulate matters for discussion or documentation,
Yes.
is there no restriction? For instance, imagine the member decided to circulate an encyclopedia for discussion at a meeting, a better voluminous documentation to be printed and circulated to a very huge that to count or to reject such proposal, if in terms of the cost to the company and others.
No, I think if you look at I think the Schedule 8, it contains the detail. If you look at I think the wording, it's not even supposed to be 200. There's a length, the length of the wording. If you look at the Schedule 8, at the end of the at 992, there are detailed rules on when you should let it even reach the company's registered office. And again, there are also rules. If, for example, you propose a resolution and then the resolution was defeated, you cannot just bring up that same resolution. A resolution is very similar to that at the next meeting. You have to be a bit like a cooling off period. And if you look at I think the 8, which is at page 374, these details are contained over there. But just for maybe the sake of our friends who may not be lawyers, let me quote the provision a little bit extensively. Yeah, so if you go to Schedule 8, for example, we have Regulation 5, circulation of resolution and supporting circulars of members. And let me quote paragraph A. A company shall dispense of the company on the request in writing of a member entitled to attend and vote at a general meeting, include in the notice of that general meeting a notice of a resolution which may properly be moved and is intended to be moved at the meeting, and at the like request, include in that notice a statement of not more than 500 words with respect to the matter referred to in the proposed resolution or any other business we dealt with at that meeting. Yeah, so the statement which you would like to use to explain a proposed resolution should not be more than 500 words. As for the resolution, usually the resolution may just be a 1 sentence or 2 sentences, but you may want to explain to the shareholders why that resolution and try to convince them to vote in favor of it. But as he rightly said, you should also be allowed to have an encyclopedic statement running into maybe 100 pages. So just imagine if you have about 1,000 members and having to duplicate this to everyone. That is why the lawmaker in its wisdom has said that 500 words should suffice. But one would also raise this issue, in my view, is worth raising that if you look at the length of the statements, it goes back to pre-technological advancement era, right? And I would like to believe that not a lot of thinking has gone through this aspect of the law in the wake of modern developments in communication, especially so, because like if the concern is about cost, right? As our friend said, if someone decides to do volumes of encyclopedia, if it's about cost and also the practicality of being able to send the proposed statement around, then one would argue that what about where you are using the virtual mode, right? You are sending maybe the notices by email or some others, so that maybe the length, if the person has even written 1,000 words, is not so much of a bother, like if we were to print it. So maybe I think that instead of having one size fit all rule, there will need to be some amendment so that there will be this rider that where the company has, for example, opted for maybe virtual electronic means of convening its meetings and so on, then the word limit of, if we like, 500 may not apply. But the other countervailing argument would also be that it may not so much only about cost of printing, but may also be about the precious time of members, okay? If you have circulated a lengthy statement and people, some people are really responsible, they like to read everything. It means we need to spend a bit more time of trying to read. And that and all will be a waste of time. And probably that's another reason why there's an attempt to control the length. Okay, Safo Kantanga, do you still want to make your point? Unmute yourself.
My lord, I'd wanted to contribute on the preferential shares and the equity shares, but it has been cleared.
Okay, all right. Yeah, so we also said that another fundamental right which the shareholder has is the right to receive dividends when declared. From the previous lectures and some of the other colleagues who have taught you, the point has made that the return which a shareholder has on the shares that he has acquired in the company is to enjoy part of the profit when same have declared as well dividends. And the basic rule is that dividends are not available unless and until they have been declared. So dividends must be declared before they are available. And concerning declaration of dividends, as you know, as part of the discussion of capital maintenance doctrine, there's what we call the principle of legality of what? Dividends. That is to say that before dividends will be considered as having lawfully been declared, directors will have to make a recommendation to shareholders that, of course, they are the day-to-day keepers of the books, that they are confident that the company will remain a going concern within, let's say, the next 12 months, when this portion of the profit made has been declared as dividends. And then the shareholders will have to pass a resolution to actually declare the recommended dividends as what? As dividends, and it will be available for distribution by shareholders who have shares in the company as it were. So not until that has been done, a shareholder, you cannot just be studying the books of the company and say that, oh, so much profit has made, so give my dividends to me. It doesn't work that way. And you also remember we said that shares are shows in action, not shows in possession. And that is to say that you enjoy the bundle of rights which are associated with your shares by means of enforcement legal action, right? Not just by self-help measures, but maybe going to take possession of some of the assets of the company just because we think that dividends ought to have been paid and same has not been paid, and so on and so forth. So let's keep that in mind. And again, of course, for preference shareholders, right? For preference shareholders, where maybe dividends, for example, not enough has been declared, but maybe you're entitled to a certain fixed dividend. As our other colleague explained, you can have this accumulation so that it will be carried over to the next season when dividends are declared, and you get the other unpaid arrears paid as it were. Now, let me ask this question. In terms of declaration of the dividends, will you suggest that the company should have dividend policy so that once the company has got like a dividend policy, the decision to actually recommend the declaration of dividend will not so much depend upon directors. Directors will just have to just go through the motions, but not really having to make the, exercise initiative to bring something before the shareholders. Will you suggest that it's better for company to have pre-approved dividend policy rather than having to wait every now and again for directors to decide what to bring to shareholders as being safe to be declared as dividends? What do you think? Okay, the same club. Okay. Safo can thank you, John Warris. Okay, so go ahead, John, and then Safo.
Okay. I think it is good for a company to have a dividend policy so that shareholders will be aware when dividends can be declared. For example, it also serves as a way of planning for the company. The company, for instance, for the next 5 years is planning to expand or accumulate capital to meet certain capital requirements if it's a bank or so. So it will tell the shareholders ahead of time that this is our policy for the next 5 years, that we will not pay dividend. We shall retain the profits for expansion or to enable us meet a certain capital deficiency. And also, the company can also say that, well, we will not declare dividends because we need to have certain cash buffer. All these things are policies that are going to enhance the performance of the company, and I think it's good for them, for the shareholders to be aware in advance, so that when they don't get dividends in a particular year, they know what the monies will be used for. That's my submission.
Okay. All right. Thank you, John. Yes, Safo. Safo is not there. Who else? Okay, Moto. Yeah, Moto, and then Zanu.
Yeah, I think it also matters to add to what my previous guy said. Since the shareholders are, so to speak, the owners of the company, I think such crucial decisions as to sharing of profit or dividends ought not to be left to the management of the company alone. So the fact that the dividend policy gives a bit of certainty about the going concern of the company, so to speak, so that the decision should not be at the whims and caprices of the board of directors. So that alone, I believe, goes for a dividends policy.
Okay, all right, thank you. So let's take Zanu. Zanu,
yes.
and Kennedy. Yeah.
Yes, my lord. I think a dividend policy is very important because it will bring about predictability, because the policy is definitely going to set out the guidelines. And when those events happen, then definitely you know ahead of time that the dividend will definitely be paid and will definitely not be based on anybody's discretion. So there is that certainty and predictability when you have a dividend policy. Thank you, and over.
All right, thank you. Kennedy.
Yes, my lord. Yes, my lord.
Yes, Kennedy.
I think that it will not be necessary, in the sense that policies of the companies are approved by the board, not the shareholders. So at the end of the day, that policy must be approved by the board. The position of the law is that it's the directors that declare dividends. So at the end of the day, it's the same entity. They put in place a policy. The law says that they declare dividend. So it's the same entity. So we just have to leave it to the position of the law. Depending on the circumstances, the directors can declare dividend based on what is before them and the situation at hand. Because the present circumstances or things happening now are showing us that business is becoming a lot more uncertain. Business decisions are becoming a lot more uncertain. Putting in place fixed policies and in such situations may invariably the directors will take a decision to overrule their own policy, because policies of the company are determined and put in place by the board. So for me, we should just stick with the statutory provision that the directors declare as and when they think that dividends should be paid.
Okay, all right. All right, thank you. But just a quick, just a minor correction. When it comes to declaration of dividends, as a general rule, directors recommend and then shareholders will pass the ordinary resolution. So the recommendation must come from the directors, and the directors cannot just pay without approval by shareholders. And shareholders give
Thank you, my lord.
yes, but
Thank you for that.
good. So if you look at section 76, it speaks to that. Good. Another right of shareholders is the right to share in the distribution of the net assets of the company. When we say like the net assets of the company, we are talking about where you have taken the whole of the assets of the company together, right? The aggregate, the total. And you have deducted the whole of the liabilities, if you say like liabilities, all the claims against the company and the various outgoings, outstanding payments which the company will have to make and all that, they are all part of its liabilities as it were. Now, when you have adjusted that against the total assets, what will be left is the net assets. The net assets. And you hope that you will get the total liabilities being less than the total assets so that the net will be positive. Now, where the members of the company have decided that, okay, we are no longer interested in having this company in existence. Let us pass a vote to get this company wind up, get it liquidated, so that everybody will go his way. Now, part of that, liquidator is appointed, and his business is to wind up and realize the assets of the company, to pay various liabilities, various creditors, and so on. Now, when all those payments have been made, what is left will be the net assets. So that is assets available for shareholders to share, because the company is actually coming to an end, is being liquidated. So as a shareholder, you are entitled to participate in the distribution of the net assets of the company. Now, if you are a preference shareholder, right, in respect of having a guaranteed percentage or whatever of the assets of the company, should it be returned, then you definitely get yours first according to the terms of your preference share. And what is left, if something is left, then it will be shared by the equity shareholders, as it were. Again, it is possible even when the company is a going concern, right? When we say it's a going concern, that is to say that it is able to pay its assets and liabilities as and when they fall due. Now, where the company is a going concern, it is still possible for the members to pass a resolution and say that we would like to reduce our stated capital, or we would like to return some of the assets to the shareholders. So if you remember, if you go to section 78, right, section 78 of Act 992, it governs what we call resolutions requiring confirmation of the court. And one of the resolutions which require confirmation of the court is where the company has passed a resolution to return to shareholders any of its assets which are in excess of the requirements of the company. So maybe they think that, well, we've done so well, some of the assets, we don't actually need them to remain in the company. let's take them out of the company and give them back to the shareholders. Now, once you've gone to court to get the court to pass to grant the leave, the requisite approval, then they can have the assets returned to them. And as a shareholder, we definitely participate in that. Then somebody's hand is up. Yeah, Kofi.
Hello, good evening.
Good evening, Kofi.
Okay, my hand came up much earlier in relation to whether the company should have whether the company, the policy, the how do you call it, dividend policy. And my view is more or less like it is good for it to have it, but when they realize at the general meeting that the policy, the dividend that is available is inadequate, definitely then, like we said earlier on, the managers will, or the directors will again propose to the general meeting that since the dividends that is, or the profits realized is not enough, though the policy says that yes, they should distribute, but because it is not enough, they would like to roll it on. And if the general meeting so agrees, they will. If not, the policy will just be kicked into force. So I think having a policy is one of the best options. That way, it creates some level of certainty as to whatever investment you have, and then which timelines you should be looking at to have some returns. If the returns come in, the idea is that it is not so big enough. So for that matter, we want to roll it on. That is quite understandable. That than being there and always being in the dark and not knowing what is happening. And directors are increasing salaries and other things, and they keep telling you that the company is not making profits so that they can share. It becomes a little problem. So I think getting a dividend policy is a way to go. Yeah, thank you.
All right. Yeah, I think Soa, yeah. Soa.
My Lord, I want to associate the last contributor's position. Just to add that, I believe the policy will come with a caveat that in times of trouble or when the market conditions are such that there's no need to recommend the payment of dividends, then the directors will be permitted by the shareholders to retain that amount and still reinvest it into the company.
All right, thank you. Okay, so another right which shareholders have got is the right to inspect register of members, and also the right to have their particulars entered or updated in the register. Now, this is very important despite the fact that it may sound elementary. Now, the register of members at every point in time is supposed to be a reflection of who the members of the company are. And not only that, in terms of shares, the share situation of the company, the balance of shares, how many shares have been issued, who has got what number of shares, who are the, if you like, the giants when it comes in terms of like shareholders who have got a lot of shares. You get this information from the from the register of members and all that. So therefore, you're a shareholder, you've acquired more shares, or you have transferred, right, some of your shares to other people, especially so if you are not a shareholder in a private company, because you know that in a private company, there's a restriction on transferability of shares. So assuming you don't have any such restriction, and if you, for example, transfer your shares and all that, all these details or particulars will have to be entered in the register of members. And as I said, at every point in time, members are entitled to go and inspect the register of members. And this is very important so that when it comes to voting, you know that nobody can rig it and everything will be done properly, as it were. I've seen some hands up. Yeah, so if you put your hand up previously and you finish, you can put your hand down so that we know those whose hands are up fresh. Is it Kennedy? Kennedy, is your hand up again? No?
Yes, my lord.
Okay.
I'm just adding that the right to inspect the register is under section 36. So if that can be added.
Okay.
I see only section 35 on the entry onto the register there.
All right. Okay. Thank you. Okay. So, all right. Thank you. Okay. Another right is the right to approve major or significant transaction. So this is very important aspect of the right which a shareholder enjoys. And again, you go back to section 144, where we have like a division of powers between the members in general meeting and then the board of directors. Despite the fact that directors are responsible for the day-to-day management of the company, there are certain matters which they have been substantively deprived of power, and they must go back to shareholders. So being a shareholder, you have the unique entitlement, the unique right to decide whether major transactions or significant transactions should be undertaken or should not be undertaken. And if you go back to anatomy of corporate law, that's the Crackman and co, he will identify 3 different characteristics of corporate actions, which require shareholder approval, which requires that directors don't just exercise their managerial discretion. They must go back to their power base, that is the shareholders. And what are these characteristics, or what are the 3 signs which will trigger the necessity for the exercise of this right of the shareholder? So A, the size of the corporate action. That is to say that the greater the size of the particular proposed corporate action, the more likely the law will need to provide for shareholders to grant the approval. Then 2, where decision involves an investment type decision. Investment type decision. That is a very major transaction which the company is going to divert its resources into. And finally, where the decision involves conflict interests. Conflict interests, where directors, for example, are supposed to have their interests not necessarily aligned with that of shareholders. And for that matter, it is not safe to leave such a decision to managerial discretion of directors. So it is better to go back to the people so that they, and the people here are referred to like the shareholders, and they will exercise that decision. And that is why section 145 of Act 992 is quite pertinent, and all of us must be familiar with it. So if we take section 145, for example, I quote, 1, a company shall not enter into major transaction unless the transaction is A, approved by special resolution, or B, contingent on approval by special resolution. Yeah, so we have been given the general rule that the general requirement which you must satisfy before the company can embark upon any transaction which is characterized as a major transaction within the meaning and purview of section 145 is that special resolution must be passed first, or subsequently special resolution should be passed to regularize it before such a transaction will be valid. So for that matter, we want to understand what constitutes major transaction, for which reason a special resolution will have to be passed first or immediately thereafter. Of course, Crackman and Co. have given us certain 3 defining characteristics. I mean, those are just a general thing. They are not the specific provisions in our law. So let's look at the specific provision as per section 145 subsection 2, for example. So 2B, major transaction means 1, the acquisition. Let me do this just for the sake of those who don't have your legislation. Let me stop, and then I will show. Let me show my legislation online. It's a minute. Let me show the legislation online. Section 1, good, okay. Let me analyze it together. Okay, so let me show this thing on the screen for us to look at it together. Go. So this is the section 145 of Act 992, which I said governs the major transaction. And I had earlier quoted section 1451 to say that it is mandatory that a special resolution is passed either before or immediately thereafter. That is all contingent on approval of a special resolution. And then we wanted to understand when we say a major transaction. Anyway, before I even move on to this major transaction bit, can somebody tell us the difference between special resolution and ordinary resolution? What is the difference? I want a lady to speak. The difference between special resolution and ordinary resolution. Any lady can unmute herself. The difference between special resolution and ordinary resolution, what is it? Any lady can unmute herself? Yes. MNB, go ahead.
I was going to ask another question, but let me attempt it. So for the special resolution, you require, I know you require 75% or more of those entitled to vote having voted in favor of the resolution, and for an ordinary resolution is 50 plus 1.
Okay, is that all?
Yes, that's all that comes to mind.
Okay, yeah, you've said some, but there are other requirements. Yes, who will add to that? Yes,
my lord.
Yes, Kofi.
Yeah. I also, what comes to mind is that with special resolutions, it doesn't come at a general meeting. It is made and circulated to all the directors and the people involved, and they must all agree to it before it can be.
No, you are. There's what you call the written resolution, which is different from special resolution.
Oh, okay, then I think I'm missing it out.
You started, yeah. Yes, Liman. Liman, you want to make input? Liman, you can mute yourself. Okay, Alfred.
Okay, my lord. I think for special resolution, we just need simple majority to be present of shareholders. No, I mean for ordinary resolution. And for the special resolution, I think 3/4 of shareholders must be present, of those who have majority shares in the company. Also, for special resolution, it goes into the core of the business of the company. It goes into the core of the business. Please, can I go on?
Yes, go ahead.
Yes, by ordinary resolution, the meeting doesn't go to the core. The agenda doesn't go to the core of the business of the company. It means what is going to be discussed is not anything substantially for ordinary resolutions.
That lied to you. Lied.
No, please.
No, you can ask that.
Please mute yourself.
Ask that. Daddy can be able to explain better to you. Go and take my other phone and call and ask me before you move your address.
From the house, Deborah.
Call Daddy on WhatsApp.
Deborah.
Hey.
Yeah, put your mic up. Yeah, because of time, let me tell you. I wanted us to finish this class earlier. That will drag on. I said that yes, ordinary resolution, you've explained correctly. It requires just simple majority, as she said. So once you've attained the usual quorum for holding meetings and all that, if the majority agrees, then that resolution is carried. Special resolution, you need 3/4 or 75% endorsement, and that's approval when during the voting for them to agree. But that is not enough. The notice convening the meeting must also indicate the proposed special resolution. So before people come to the meeting, when they receive notice calling them to attend the meeting, they will have also seen the proposed special resolution. So there must be a prior notice about the proposed special resolution before it is put before the meeting. Ordinary resolution does not require any prior notice, as it were. So let's keep that in mind. And of course, special resolution must also be registered right? You also have to register it with the registrar of companies after the meeting. So let's keep that in mind. Now, so we are saying that section 145 requires that a major transaction must be approved by special resolution before it can be undertaken. And we are trying to understand what a major transaction is. So if you look at section 145, subsection 2B, it defines major transaction in these terms, as we can see on the screen. And I quote, major transaction means I, the acquisition of or an agreement to acquire, whether contingent or otherwise, assets, the value of which is more than 75% of the value of the assets of the company before the acquisition. Okay. So if the transaction you intend to do, if it's going to be more in excess of 75% of the assets of the company, then that is a major transaction. If you are going to acquire anything or where the value of it is more than 75% of the value of the assets before the transactions embark upon, then that's a major transaction. Or if you are going to enter into transaction to dispose of, or an agreement to dispose of, whether contingent or otherwise, assets of the company, the value of which is more than 75% of the value of the asset of the company before the disposition, then that is also another transaction. That is to say that directors are not given the power on their own just to take a decision and, for example, dispose of about 75% of the total assets of the company without involvement of the shareholders. That is not permitted. Neither are directors also permitted to take any decision to try and bring something in excess of 75% of the value of the assets of the company without the shareholders' involvement. Or three, a transaction that was likely to have the effect of the company acquiring rights or interests or incurring obligations or liabilities, including contingent liabilities, the value of which is 75% of the value of the assets of the company before the transaction. So the third scenario is looking at various permutations of the two earlier scenarios, right? You can have various permutations or configurations of various variants of that. So all those things will be taken care of under III. Yeah, so if it falls within that, then that is a major transaction, as it were. And of course, in trying to compute the assets of the company, right, in trying to find out whether it measures up to 75% or more of the assets of the company, the C is saying that we include assets of the subsidiary of the company as well. So we are talking about where you have a parent company, then where you have like a subsidiary company. Then the assets of the subsidiary company will be reckoned as part of the parent company if you want to determine the 75% threshold for purpose of making a determination as to whether what is at stake is a major transaction or is not a major transaction. So let us keep that in mind.
Hello, please, I didn't get the section again, for the major transaction, please.
Section 145.
Thank you very much, sir.
Yeah, 145. Okay, now let's look at the remedies of shareholders, and then we'll be making progress. Good. So if you are a shareholder, okay, and you are aggrieved by how you are aggrieved in terms of you are not satisfied, your rights have been interfered with, infringed upon, and all that. You have two main options available. One, leave the company. If you leave the company, then you're not part of it. So that you go with your grievance, isn't it? Then you don't care what happens in the company and so on and so forth. So you may do this by selling or surrendering your shares. Or the other option is litigation. You sue to enforce your right, as it were. So I'd like to find out from you, with respect to option one, are there any practical challenges? You are a aggrieved shareholder and you want to call it a quit. You want to live like the company by selling or surrendering your shares. Are there any practical challenges with that? Because it sounds easier. Do you foresee any practical challenges with that?
Yes, my lord.
Yes.
Yeah, I think there are some practical challenges, because sometimes when you look at the kind of investment you have invested in the company, for how long you have been with the company, the progression levels, all the dividends that you even suspended and did not even fight for, and all that. Now that things are a bit juicier for us all to enjoy, then maybe they are doing things that are now trying to take your rights away from you. So just selling your shares and leaving the company will be a very, very painful experience. And I think in such situations, litigation will be the best option. Right, thank you.
All right, thank you. Okay, who else? I think there are some few other hands up. Sylvester.
Yes, Your Lordship. One practical challenge that I see would be the value of your share at the time of exiting. And so if, for instance, you decide to leave because you have certain grievances, then what would be the value of your, how do they assess the value of your share at the time of exiting? So that would be one of the challenges a shareholder may go through or may face.
Yeah, you are correct, but there's one particular thing I want to hear in terms of that, the challenge of living. There's one particular challenge. Yes, Gulo.
My lord, where you need the company's permission to sell the shares.
Okay, so and that one is applicable in what situation?
My lord.
When will it be a requirement for you to get the company to agree before you can, sell your shares?
My lord, when it is clearly stated in the company's constitution that you need the company's permission to sell your shares to a new shareholder. In that case, then the individual will need the consent of the permission of the company to go ahead and.
All right, especially in the case of a private.
The 75% rule come in here?
No, the practical decisions, if you're a shareholder in a public company, especially a company which is listed on the stock exchange, then it's not a big deal. I mean, even for such shareholders, they are even like they're like atomistic members because like you have so many shareholders, and their shares are changing hands every now and again. So that one is easy. Or if it's not a listed company, if it's even not like a listed company, and it's a public company, as some of you rightly pointed out, there are no restrictions on transferability of shares. So be able to transfer. But the practical challenge is this, the pricing, right? At what price are you going to sell the shares? Will you be able to get a fair price in terms of like the rare value of the shares according to how well the company is doing and all that at that particular moment and all that. So these are some of the practical challenges. Now let's look at litigation. Some of you said that litigation is the best option. Are there any obstacles to litigation as an option?
Cost.
Cost, okay.
And time you spend litigating.
Okay. So cost and time. What else? Are there any other obstacles?
Yes, my lord. Sometimes it brings the company's name into some bad lights in the eyes of the public, and that would then in turn affect the fortunes of the company.
Okay. Okay. All right.
My lord, we can also talk about enforcement of court judgment, even if it is in favor of the shareholder who want to sell and leave the litigation. Because if you win and the company has a legal team that is very unsuspecting, the back and forth will delay the processes for a very long time.
Okay. I think what we need in Ghana, and maybe some of you, maybe you may want to take up this idea. There's what they call it the organized shareholders action or shareholder activism. So you can get, I mean, we need organization which will rally shareholders, right, from various companies, and then they can create a fund so that they will be able to recruit or hire lawyers and other corporate experts to actively pursue their rights for them without they thinking about the cost. And so where you have, if you like, a very robust and standby legal and other professional team to help shareholders to be able to take up their claims against their respective companies, I think that will be a game changer. And it will also be less burdensome for individual shareholders in terms of cost, in terms of timing and all that. And some of these bodies can even be given power of attorney, right? The shareholder give power of attorney to them so that the shareholder doesn't even have to go to court. Just those organizations and their lawyers, which will be fighting their grievances on their behalf, as it were. Maybe something some of you can think through and take it up in the country. Don't tell me that I'm instigating litigation. It's against my profession. Okay, so let's say a few more things about the litigation option. So one, we have what we call the personal action. That is where a shareholder brings up a suit, brings up a case, that is an action, for infringement of his personal rights. If I say his personal rights, things which affects him or her in his or her personal capacity as a shareholder, as it were. Any of the things pertaining to, if you like, his bundle of rights as a shareholder, qua-shareholder, that could be taken up as a personal action. So for example, if we take section 218, which is a provision which enables the shareholder or member to get an injunction, right? To get an injunction, for example, from the court to restrain the company from embarking upon something which is an illegal. That in the past, you might have heard of something called the rule in Force and Habertel. There's a very old case, a 19th century case. Force and Habertel was a case, a transaction had been done, and later on, the company had a meeting, the members passed a resolution trying to approve that which appeared to be irregular, which some of the directors had done. And someone who was aggrieved went to court. And then the court said that the action that he was trying to bring was an action which will not be entertained by the court, because the court said that there are two things at stake whenever there is a case involving and concerning the company brought by a member of the company. One has to do with what we call the majority rule, and the other has to do with what we call like the proper plaintiff rule. By the majority rule, the court was trying to make the point that the company decision system follows the democratic principle of minority will have their say, but the majority will have their way. Because when we have to make a decision, we take the majority position. And for that matter, whatever the company can use the requisite majority to approve by way of resolution, the court was not going to interfere with that. Because if the court did, the company, they can have a meeting, pass a resolution, and undo that which the court has, for example, ordered, because their constitution, for example, enables a certain majority to approve that particular transaction and so on and so forth. And for that matter, at common law, what courts try to avoid is to become a laughing stock, is to appear to be impotent as giving orders which the court cannot enforce, or giving orders which can legally be reversed by some other entity. The court tried to avoid that. So that was part of the reason why the court entertained the majority principle in Force and Habertel. Then there's also something we call like the proper plaintiff rule. And then the proper plaintiff rule is to the effect that where the company has suffered a wrongdoing, the proper plaintiff, that is the right person to sue, the right person to take up the matter, is the company and not any shareholder or any member, as it were. But of course, this so-called rule in Force and Habertel is no longer necessary, because it's been overtaken by so many modifications in the law. And that is why it's even not necessary to be mentioned it in the corporate law class, but just to let the company know why they come across it in the textbook. That is why we've mentioned it. So therefore, if we take section 2.1, if we take section 218, for example, it says, and I quote, the court, on the application of a member, may by injunction restrain the company, A, from doing an act or entering into a transaction which is illegal or beyond the power or capacity of the company, or which infringes a provision of the constitution of the company, or B, from acting on a resolution not properly passed in accordance with this act or constitution of the company, and may declare that act, transaction, or resolution already done, entered into, or passed to be void. Good. So section 218, for example, may be invoked by aggrieved shareholder and say that this particular act, which the company is doing, is illegal. It's not in accordance with what the law says or what the constitution of the company says. There are times that the shareholder may not only be seeking to ensure legality principle in the company, but may also be seeking to ventilate his or her own personal grievance because the company did not follow, let's say, the laid down procedure in this constitution. A certain benefit, which is supposed to come to him as a shareholder, for example, is, for example, not getting that. So despite the fact that he is using section 218 to ensure legality, in a sense, he's also trying to protect his own personal interest, as it were. And the same thing applies to the rule or the principle against oppression. As a shareholder, you can invoke section 219 to get a remedy against oppression. And oppression is a very big concept which encompasses various types of grievances, various types of improprieties, various types of wrongdoing, which the company may be complaining of against, the member may complain of against the company. So, for example, it may well be that the member is saying that the way and manner affairs of the company are being run are improper disregard of his or her interests as a member, or it constitutes unfair prejudice to his interests as a member. That will be a legitimate situation for the court to intervene and give a remedy against oppression. Or sometimes a member may even go to the registrar of companies, make certain complaints, or make certain complaints concerning how maybe some directors or some people or some controlling shareholders, majority shareholders, for example, have hijacked the company and they are using it to undermine its interests as a shareholder or member. So the register of companies may even appoint inspectors, right, to go into the company, conduct investigation, conduct inspection, and then produce their report. And if at the end of the work of the inspectors, the register of companies becomes convinced that, yes, we have come across evidence suggesting that some controlling shareholders have actually hijacked the company and they are using it to work against the interests of a particular shareholder. And for that matter, the court should intervene and make necessary remedial measures to salvage this particular member from oppression. That will be done. That will be done. And sometimes the remedy against oppression in this particular case may even be that the court could even go to the extent of ordering the company to value the shares of the particular shareholder and pay the shareholder the amount of money his shares is worth, or some other consequential relief which the court considers to be necessary to remedy the situation. Now, apart from that, we also have representative action. But before I move on, I think I saw a couple of hands up. Let me take them. Oh, no, they are down now. Yeah, the person who signed this up, you can just speak. Somebody hand this up, you can just speak. Okay, maybe it's a mistake. All right. Okay, another remedy is a representative action. A shareholder may also embark upon representative action. And this is where the shareholder brings up a case, not only on his own behalf, but on behalf of a group of shareholders who have got the same personal rights that have been infringed. That is to say that the particular right which the shareholder is complaining of having been infringed, that same right has also been infringed for some other shareholders. So he's not alone. There are other shareholders having the same right that has also been infringed. Now, where that is the case, then when the shareholder takes up the matter, he goes to court. He's not going only for himself. He's going to court for and on behalf of all other shareholders who are similarly affected. Shareholders who have rights or interests which have been violated in the same way as our friend, the shareholder. So representative actions are governed by Section 205 and Section 325. And it simply says that where you bring up a case in a representative capacity, you must, it is prudent to notify other shareholders who have got the same right like yours, which has been infringed, so that they all come and bear the responsibility involved. On the other hand, if you decide to go solo, the outcome of your action will not be enjoyed by you alone. If you are successful, it will be enjoyed by you and all those who have the same right which have been infringed. On the other hand, if you're unsuccessful and cost is even a slap on your face, you have to have a private funeral and weep alone and bear the cost and bear the cost by yourself. So if you want to be wise, you try and get all those who have similar interests, rallied around you, so that if you have to make contribution to finance the litigation and all that, you get that done. Especially so if you are victorious and you alone, you are not going to enjoy the victory. All those who also have that same right to enjoy it, then why take the risk and go alone? So please look at Section 205 and 325. If you wanted example of maybe a representative action case, that would be a case relating to, let's say, enforcement of a registered constitution of the company. Now, if you take a registered constitution of the company, we know that it is a contract under seal between the members and the company, between the officers in the company, between the members and the members inter se, officers inter se, and so on and so forth. So therefore, where provisions of the constitution have not been complied with, and you need to sue to enforce it, certainly the constitution is not for you alone, it's for all members. And whatever right you have, for which reason it has been infringed and you want to enforce it, would also apply to other shareholders. And for that matter, you have to bring it up as a representative action case, as it were. We also have a special statutory right to take action for wrong against the company. Yes, let's some two hands up. Okay, Mame, Cesar.
Good evening, my lord.
Good evening.
Especially section 325 talks about rotation of directors of a public company. Could you please explain the linkage between it and the representative action?
325.
Yes, please.
Let me see. You have quoted the wrong provision. Okay, I think the 325 is probably a carryover from that. Is it a repeal at 179, if I'm not mistaken? So it will not.
The 179 was 324.
324, good. 324. Yeah, so it will not apply to the Act 992, because the 324 and then is what has been reenacted as section 205. Because if you look at the at 179, the 205 in those days were around the duties of directors and the rest, isn't it?
That's correct, ma'am.
Yeah. So I think ignore the 325 because the rotation principle applies to directors. It applies to directors in public company, not private companies. And you know how it works, don't you? You've done directors, haven't you? You do
we
directors.
have, my lord.
Okay. Okay, so we are not doing directors, but simply the rotation principle requires that in a public company, you have to avoid situation where all directors retire at the same time. And the idea is to preserve what we call the institutional memory. So I think if you look at the detailed rules, at least at every point in time, only 1/3. You have maybe about like the 1/3, if you like, remaining, or 1/3 retiring, as it were, so that you don't find a situation where the boardroom, you have completely new set of directors and nobody knows anything, which happened last year or last month. And that would not be good for the boardroom deliberation. So it's just attempt to preserve some kind of institutional memory. So that's the basis for the rotation principle. I think another person's hand was up. Mami, yes. Oh, that's it. Oh no, that Mami has spoken. Is that the same Mami who spoke? Or is it Mami BY? Okay.
Sir, respectfully, I would wish you throw some light on the written resolution, because I want to know whether or not when there's a written resolution by shareholders, it is a requirement that all of the shareholders who are entitled to vote must vote in favor of the resolution before a written resolution will suffice.
Okay, good. Okay, so section 163 governs what we call written resolution. And a written resolution, according to 163, quote, a resolution in writing signed by all the members for the time being entitled to attend and vote on the resolution at a general meeting or being bodies corporate by the duly authorized representative of bodies corporate is as valid and effective for purpose of this act as if the resolution had been passed at the general meeting of the company duly convened and held. Good. And written resolution can be used for all things except if you like two things: removal of a director and then removal of an auditor. These are the only things we cannot use written resolution. And as the provision I quoted 163 says, all members who are entitled to attend, if we were to hold like a physical meeting, all those who are entitled to attend must sign the written resolution before it will be considered as having properly been passed, as it were. So in terms of practicality, you know, the threshold is very high. Just imagine if you have about, if you have about, 40 members who are scattered, right? Who are scattered all over the country. How you have to move, you have to move around or to get everybody to sign. That is problematic. But now that we have electronic signature, right? Maybe the argument will be that electronic signature will make it easier to get written resolution also done, as it were. Mame?
Sir.
Yes, you have some other questions on that, or we can move on.
Yes, sir. So my question is, when it comes to a written resolution, is it that all the shareholders must vote in favor of a particular resolution before it suffices? That is, can there be a situation, even though the shareholders use a written resolution to determine the resolution, some of them voted in favor for, and then some against? Is my question clear?
Oh, okay, right. I think that the law says that it should be signed by all. So all of them, of course, if you have a resolution, it will either be yes or no, isn't it? You have like the resolve that we buy a new pickup for carrying customers' goods. Yes or no? Then Mame Boachi, yes, you sign it. Kaku Musi, no, over there. So I think the emphasis is on everybody signing it. It doesn't mean unanimity of like you should have 100% before it be carried.
Very well, my lord.
Yeah, because the provision said that is in right signed by all the members for the time being entitled to and vote on resolution. Yeah, so I think that everybody should sign it. So we are not, so over here, we are not applying the, what do you call the quorum principle, right? If we're having a physical meeting, once quorum has been met, we can go ahead and pass the resolution. But written resolution, the quorum is 100% of all those who are entitled to what? To attend the meeting. So that is the only difference. But in terms of the getting the resolution passed, of course, it will still be the same principle. if it's ordinary resolution, which is supposed to have been passed, the simple one, yeah, so it will not really be different.
Good for my lord, it's okay.
Yeah.
Understood it.
My lord, just a quick one. In reference to what my colleague just asked.
Yes.
So for the written resolution, if you say that probably it goes like this, the company has resolved that on the 1st of April 2023, we are going to get, let's say, 4 Land Cruisers.
Okay.
That is the problem. That's going to be the resolution. Now
Okay.
there are about 10 shareholders.
Okay.
9 of them are in agreement to the purchase of the vehicle.
Okay.
1 of them is not in agreement, and that 1 person who is not in agreement would not sign. So if he doesn't sign, that means the written resolution will not hold. If he signs, that means all of them are in addendum. That is that I think that is a contention she's looking at. That should all be in addendum, like should all have the same mind or objective.
Okay. All right. So that, like, going by your illustration, the 10th person, right? The 10th person, he doesn't have to agree, but he has to sign no. So they have evidence that he signed.
Signed. Okay.
Yes. There should be evidence that he signed, but of course it's going to be like a negative vote, but it should be present on the face of it. And let me convince you why the interpretation we have adopted is the correct one. Now, if you look at section 163, right? It says, and I quote, a resolution described as a special resolution is a special resolution within the meaning of this act, okay? Now, and again, if we look at the 4, a resolution is passed on the date on which the resolution was signed by the last member to sign. And where the resolution states a date as being the date of the signature by a member, that statement is sufficient evidence that the resolution was signed by that member on that date. Now, if you read these 3 subsections together, you get the sense that the lawmaker even permits written resolution to serve as a special resolution. So all that we need to indicate on it is that this is a special what? Resolution. And if it's a special resolution, you know the special resolution must have 75%. So if all those who are entitled to attend the meeting have actually appended their signature, when you do the mathematics, 75% of them must actually endorse or must agree with what the resolution is proposing.
Oh, okay.
So quick one. What
I
if,
think,
we
excuse me,
decide-
Cosmate, just a quick one. So I think why we are interested in this is that we've had, I think, corporate governance, or yes, one of the classes, and we spoke about this, and the lecturer was emphatic that for the written resolutions, the decision must be the same, unanimous, before it can be carried. I think it was Clara Casati. So that is why we're trying to find out the differences.
No, he never says you unanimous.
There is something we call unanimity principle, right? The dogmatic rule, the unanimity principle is different from written resolution. Yes, it's similar but not the same. The dogmatic rule, the unanimity principle is similar how it was, but not necessarily the same. Okay.
So just a quick one. I'm a bit confused here. So let's assume 2 members decide not to sign. And what does it necessarily mean the resolution has failed?
If they decide not to sign, and the law says that all members who are entitled to attend a vote on resolution. So if he does not sign, then the requirement of the law per 1631 has not been met. Because the law says that all those who are entitled to attend and vote must actually do what? They must sign.
So then the resolution fails.
Yes. So there's no, it's not even a question of it even fails, there's no resolution. If you say fail, right? If you say fail, let's assume that you intended to do special resolution. And special resolution, we are told that you should have, please, the one who has got a child at the background, can you please mute the mic? Thank you.
He's also a student too.
Yeah, so if, let's say that those who signed the written resolution, you did the mathematics, and those who are supporting the resolution, they are less than the 75. That way, you say that the resolution is lost. It's not correct because we haven't met the required approval. On the other hand, like the example that you give, if you have 10 members who are entitled to attend and vote, and who have said that they will not sign, yes or no, then you cannot take advantage of 163. And that is why I did that. In my view, what 163 seeks to do is that the quorum principle is what is ignored, is sacrifice.
The sabotage.
Principle actually enables, you get a certain minimum number of people who are present for commencement and valid transaction of business. But when it comes to written resolution, because we are not going to hold a meeting and have discussions and all that, the raison d'etre of the law is that let us ensure that everyone saw the proposed resolution. Even if the person disagreed, he or she saw it. Now, if we had like a meeting, if you had a meeting, you could have sent the proxy or so on and so forth. And that is why quorum can be used to bind you. But in this situation, we cannot bind you if you didn't actually put your signature on the document.
My lord.
My lord.
My
So,
lord, resourcefully.
But we are about
My lord.
100. I'm sure one day one of you will bring a case in court, and then we have maybe authoritative judicial pronouncement on it.
My lord.
Yes.
My lord. My lord, just to speak for the few, some of us, the full batteries are going off, and I think they are leaving. If you can kindly bring the meeting to an end. Thank you.
But you know, I was doing my class and you brought other topics, and that has taken my time, isn't it?
Yes, because yes, my lord, because we were studying the 2 hours, and
Okay.
Oh,
right.
thank you. I'm here. My last question.
Please let me finish what I want to tell you, because I understand you want to leave. So let me finish.
I'm not leaving.
So you hold on. When I finish mine, then you come in again. All
Person
right.
do be very careful.
Yeah, so please, if you look at section 200, it's about enforcement of directors' duties. So if you look at directors' duties, for example, one will argue that if directors default, it is the company which has actually suffered a wrong. And using the language of Force and Hamilton, one will say that the company is a proper plaintiff. But here is the case. The lawmaker has conferred right on the shareholder to be able to sue and enforce it. So if you look at 200 subsection 1, it says that proceeding may be instituted by the company or by a member of the company. Good. So let's pay attention to that. Then finally, let me talk about derivative action. Derivative action, section 201, very important. So this type of action may be brought by a member where the wrongdoers are in control and prevent the company itself from suing. So the company has suffered the wrong, and the wrong which the company has suffered is actually being perpetrated by those who are in charge of the company. And since Lord Cranworth, in the well-known case of Aberdeen Railways against the Blackie brothers, has made the point that the company does not have a hand and leg. It doesn't have a flesh and blood. It functions through the instrumentality of what? Of the directors. Now, if the company has a claim, it's the directors who actually call the shot. But let's suppose that some of these directors or some of these controlling shareholders who have passed a requisite resolution for the company to take up the case are those who are the perpetrators of the wrongdoing. So, as somebody said, who watches over the watchman? Who is going to call these wrongdoers to account? And that is why, in the wisdom of the lawmaker, Section 201 has created what they call the derivative action. And derivative action, a member, for example, could just go to court and seek leave, get permission of the court to bring a suit in the name of the company, to sue in the name of the company, in order to ventilate some of these claims which the company may have. Okay, so on that note, we will end the class here, but just before we end, let's take one or two questions. Yes, somebody said he or she wanted to talk before I continue. Who is that?
Yeah, this derivative action.
Okay.
I think the clause says that the company will have to pay the legal costs of the shareholder who's taking the issue to court. And a friend tried it, and the lawyer was going to charge more than what is prescribed in the Companies Law Act. So I don't see how a shareholder who is not very resourced can take action.
No,
under this law.
the Companies Act does not prescribe legal fee. The lawyers, they have what we call the Ghana Bar Association, as what they call the scale of fees, which they approve. And I think the latest one they approved was last year. And the General Legal Council, which is the regulatory body under Act 132, has also given its imprimatur or its benediction to it. And for that matter, where there is doubt as to what the market price is for a particular legal service, we can profit by looking at the Ghana Bar Association scale of fees. And if you go to the Ghana Bar Association scale of fees, they have a segment on what we call the corporate litigation, shareholder, directorship litigation, all that. And the figures are there. So I think, but in order not to unnecessarily, inundate the company with unnecessary expense, that is why Section 201 says that you must go to court and get leave of the court first. You have to get leave before you start derivative action. You don't just start. You don't just start. So you have to get leave. If you get leave, what it means is that the court has given a blessing. The court has given approval that you can sue in the name of the company on behalf of the company, so that at the end of the litigation, we can get your expenses and costs, properly, organized in account form, and then you make a demand, or you can even go to the court, and then the court can even make orders for the company to pay you, and so on.
Okay. And the last question, the written resolution. Assuming I know that we are 10, and I know that 9 people will vote for, and I want to sabotage it. Say I can refuse to sign, and then they cannot carry through the resolution.
Yes, if you refuse to sign, then there's no written resolution.
But is there any way that these 9 people can go to court and find a way of
so why not then call a meeting? If you call a meeting, the threshold, the quorum rule is there, isn't it? Call a meeting.
Okay.
Yes.
Okay.
Okay.
Thanks.
All right. Any other? Okay. Good night.
Good night.